The Honorable, the Supreme Court.
Thank you. Good morning. Please be seated. Dale?
Good morning, Your Honors. The matter before the court this morning is the case entitled Michelle Morin and Karen Rowell v. City of Burlington, case number 25 AP 072. Representing the appellants, Michelle Morin and Karen Rowell, is Attorney James Hassan. Seated at counsel table with Attorney Hassan is Attorney Brady Tunsing. Representing the appellee, City of Burlington, is Attorney Eric Ramakrishnan. Seated at a counsel table with Attorney Ramakrishnan is Attorney Ryan Kane.
Thank you. Counsel for the appellant, please approach the podium, introduce yourself and your client, and then you may proceed with your argument.
Good morning. Thank you, Your Honors, and may it please the court. James Hassan for plaintiff appellants Michelle Morin and Karen Rowell. I'd like to reserve 3 minutes of my time for rebuttal, please. This case squarely addresses an issue that this court left open in Ferry v. City of Montpelier, whether a particular election organized by a locality is nevertheless subject to Section 42 of the Vermont Constitution because it concerns a Freeman matter. The city argues that whether an election is local or statewide, quote, depends simply upon the level of government at which an election is held, end quote. But it concedes that the vote in Martin v. Fulham was a state election in substance, even though it was occurring at town meetings. Despite this concession, the city and the state rest their defense of Burlington's charter amendment on paragraph 36 of Ferry, which held that the distinction between municipal and state elections is, quote, categorical, and that Section 42 does not apply to municipal elections as a matter of law. But the fact that the distinction is categorical only means that an election either concerns a Freeman issue or it doesn't. It does not mean that an election is outside the scope of Section 42.
So, Mr. Hanson, why is it Hassan? Is it
Hassan, Your Honor.
Mr. Hassan? Sorry about that. So why wasn't this a municipal election?
Say again, Your Honor.
Why wasn't this a municipal election?
Well, the votes on school funding are necessarily statewide because they dictate by design, and in response to this court's decision in Brigham, they dictate statewide yields and therefore statewide tax rates. It's no different from the election in Martin v. Fulham, where the vote, quote, the vote thereon, though taken by towns, was in essence and effect a vote of the freemen of the state.
Can you explain to me how the municipal vote in Burlington with mathematical precision would affect the statewide funding? Or is it just
down to the degree of the last dollar, Your Honor? I haven't ran those calculations, but the voters approve the budget, and budgets in aggregate determine the statewide responsibilities, and the yield then dictates what the state needs to provide from the education fund, under which then homestead tax rates are established, baseline homestead tax rates.
the equalization formula?
Exactly, Your Honor. Yes.
So we know there is an equalization formula, but we don't know how the equalization formula gets affected by the municipal vote from the city of Burlington?
Oh, I was just saying that I didn't have precise numbers in front of me to the extent to which. However, what I can tell you is, and this is in the record, that Burlington voted $96 million more in funding from the education funding than it contributed in tax revenue. And so once everything is equalized, that in turn is is calculated to determine what the state's obligations, its spending obligations on a per pupil basis. And from there, based on those obligations, the state sets tax rates. So it is a direct line between municipal votes approving local budgets that feed into statewide obligations that dictate statewide tax rates. And this is summed up very clearly, actually, in this court's decision in Boyd. It's 216 Vermont 272, paragraphs 5 through 7. This court summarizes how that flow works, Your Honor.
Isn't this case really more, your concern in this case more about the use of equalization than non-citizen voting?
The statewide nature of the education funding system in Vermont, which is unique to Vermont, is indicative of the statewide character of the votes at question. This isn't an instance where a locality's decision just happens to bleed a little bit across its borders, and the allegation, like the allegations in Ferry, are that there's some kind of extra municipal impact, like a zone of influence. This is by character, and again, by design, a statewide funding mechanism. And that's because this court held in Brigham and reaffirmed in Athens School District that Section 68 of the Vermont Constitution, which is in Chapter 2, just like Section 42, requires essentially the type of equalization system that the state set up, or the legislature set up in response to this court.
But the voters in Burlington were voting on how much they wanted to spend. They weren't voting on how they were going to pay for it.
That's correct, Your Honor. However, they're voting on how much they want to spend necessarily dictates how much the state is going to spend, and therefore how much the state is going to tax in order to come up with the revenue to do so. So necessarily, in aggregate, all of these school budgets fund the statewide appropriation and therefore the statewide tax burdens. So whereas they're deciding what they're going to spend, that is not something that's isolated in a vacuum.
So,
And I think we laid this out very clearly in our complaint and in our briefing, Your Honor.
so post Brigham, any vote on a school budget, if I'm understanding you right, implicates statewide concerns, touches the state, and no non-citizen voting on any of them anywhere.
On school funding, on
On
school
school
budgets?
funding.
Yes, Your Honor, because in Ferry, in Your Honor's
I'm a bit
opinion in
familiar
Ferry,
with it, just a
we
bit.
said that this was categorical. And our position is this falls very clearly on the statewide side of things.
No, yeah, thank you.
You mentioned, I'm sorry, go ahead.
Go ahead.
You mentioned Brigham. It sounds like what you're saying is that the decision in this case in some ways is required by Brigham, that you're asking for. That Brigham, just because of the way Brigham was issued, it requires a statewide mechanism where things from one town touch on things from another financially, and therefore the court has to rule your way.
I think that Brigham and cases like Stowe Citizens held that the education funding is, quote, a fundamental obligation of state government. And therefore, it flows as a matter of logic that education funding is a statewide issue. And because Ferry said we distinguish between municipal issues and statewide issues, school funding falls on the statewide side of things. And my friends on the other side have not pointed to a single instance in which voters approve statewide expenditures or make decisions that directly affect statewide tax rates that isn't, a Freeman issue.
Part of your argument is that it, quote, touches, right? It touches on the other aspects, it's other concerns in the state. Because that's under section 42.
I would say that, yeah, it directly, it not just touches, it dictates.
But isn't the word touch in that section something that you focus on, that your position is it touches it, therefore the court has to find that non-citizens can't vote in school budget elections?
I think we mentioned the voter's oath where it says any matter that touches and concerns
And
the
that's-
state of Vermont.
And that's what I'm getting at. The voter's oath is not the more substantive provision above.
And that's correct, Your Honor. And that's what I was about to say immediately after is that that's not, the whole substance of our argument. And it's not actually even what our argument is grounded in. Because I think this court, in Justice Eaton's opinion in Ferry, had a very coherent explanation of where the voter's oath fits in with the rest of Section 42. But Ferry did hold that a vote municipal name, but traditionally the province of Freeman in substance, cannot escape the requirements of Section 42. That's paragraph 50. And be hard pressed to think of another vote that is local in form, but traditionally the province of Freeman in substance, than voting on matters of education funding, which this court has held, are statewide matters and are designed by the legislature to be statewide in impact. And the law couldn't have its stated effect if individual votes did not have statewide impacts.
In addition to Brigham, you've mentioned teacher salaries as an issue of statewide impact because of the way pensions are funded. Is that independent of the education funding formula? Is that a concern that's independent?
That is independent, Your Honor. That's an
So
independent corollary argument.
if we adopt your test, are there other issues in town budgets, like teacher pensions, that would be statewide issues?
The court is free to rule that way, Your Honor, but I think a more direct through line would simply be we're dealing with statewide expenditures. However, to the extent that the obligations flow directly from state voters to or from local voters to statewide expenditures, I think that's an appropriate test. And we would hold that, just like votes on school commissioners, that the process is so integral to the decision about statewide funding that they're tied up in statewide in matters. But this court, if it disagrees, can make a narrower holding that the test is whether or not votes are in aggregate dictating statewide expenditures, which is what is happening when schools approve municipal budgets. And I see that I'm running into my rebuttal times, Your Honor. If there are any other questions on this go round. Thank you, Your Honor.
All right, counsel for the appellee may approach the podium and introduce yourself and your client and proceed with your argument.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, my name is Eric Ramakrishnan, appearing on behalf of Appellee City of Burlington. And this morning, I'd like to be heard on 3 specific issues, all relating to appellant's assertion in their reply brief that this case calls upon this court to definitively delineate between what constitutes state versus local elections. Those 3 points are that, first of all, I disagree that this case requires the court to do that, and I'd like to explain why. But I'd also like to note that, in essence, this court has already answered that question, and I would point to paragraphs 45 and 46 of the Ferry decision for that, and I'd like to explain that further. And lastly, in talking about the distinction between state and local elections, I'd like to reiterate the city's position as to why this case is on point with Slayton versus I always forget the name of the town. I always want to say Richmond, town of Randolph, I'm sorry, and not Martin versus Fulham. In terms of why I don't think this case actually calls upon this court to clearly delineate in all cases what constitutes a state versus a local election, is that the test that appellants are seeking to apply is the test that this court already disagreed with in Ferry. And the primary legal authority for the test appellants propose is the voter's oath. And this court has already said in paragraphs 41 and 42 that that oath, that language is not dispositive. We have to read that the language in context of the whole section and in context of the history of the framers' intent. Appellants are asserting that we look to issues. We apply, essentially they're trying to apply the exact sort of sliding scale, fact-specific, purely local test that this court does.
We tax property on equalization ratios between every town in the state of Vermont. So what one town does may have an effect on other towns as we have a per pupil amount that gets spent. So there is a tie-in between all the towns when we do the equalization formulas.
Sure. And the city doesn't dispute that there are extra municipal impacts of local school elections, just as there are lots of potential extra municipal impacts of other types of municipal decisions. But that's not the test. This court said in Ferry, that's not the test. This court said that the distinction between state and local elections is categorical. And I would point to Stowe Citizens for the proposition that this court has already decided that those extra municipal impacts are not determinative. Vermont respects the non-delegation doctrine that the General Assembly cannot delegate legislative authority, but there are exceptions to that. It can delegate authority to local communities to decide purely local issues and, relevant here, to decide how to implement at the local level statewide legislation. And in Stowe Citizens, sort of the prototype of the current school funding, statewide school funding scheme, post-Brigham school funding scheme, was challenged on the ground that the legislature had effectively delegated its statewide legislative authority down to local communities. And this court said, no, that's not the case. This court said that communities have no control over the scheme. Communities aren't the ones deciding what types of impacts their decisions will have on the state as a whole. The General Assembly has decided that. And I would submit that in 16 VSA 4011C, the legislature has retained control over that decision. A community's budget is effectively a funding request, but it's the maximum amount that the legislature will appropriate. The legislature retains control over that. Anyway, going back to Stowe Citizens, what's being decided at the local level is local budget priorities. That's all the voters are deciding. That's what they're looking at when they look at their ballot. How that fits into the larger scheme of things, that's still within the province of the General Assembly. That they haven't delegated that. And if they had delegated that, then the school funding scheme would be invalid, unconstitutional.
Council, does it matter that the General Assembly has to make the final determination of the statute and how it's going to deal with the financing issue? The town says we want X, the city says we want X, and it goes to the General Assembly. The General Assembly, we all know, is going to give them something.
Sure.
Right? And that something derives from their vote for what they're asking for in some way, shape, or form. Right?
It derives from what they're asking for, sure.
And so then, does the General Assembly's decision impact other towns?
It may, and the city is not disputing the fact that there are extra municipal impacts, but this is an issue that this court has decided the General Assembly has properly delegated to local communities. And I would look to, again, paragraphs 45 and 46 of Ferry, which I'd like to address in greater detail, to talk about how that makes it effectively a local
But
election.
Ferry was a facial case.
Ferry was a facial case, sorry.
And the case went on to hold in paragraph 50 that it wasn't what it wasn't deciding. And isn't today's case what Ferry wasn't deciding?
The test that appellants are seeking to have this court apply is exactly the test Ferry rejected. So whether this is brought as an as-applied or a facial decision, it doesn't change the fact that they're asking this court to apply a test that it said is not the test.
Assume for me, please, a traditional Vermont town meeting with a floor vote and a moderator.
I'm sorry, could you repeat? I had a hard time hearing.
Assume for me, please, a traditional Vermont town meeting with floor votes and a moderator. May a voter at town meeting move from the floor to amend a town budget before it's voted upon? Yes, right?
Yes, I believe so, yes.
And may a voter at town meeting move from the floor to amend a school budget before it's voted on?
Since Burlington doesn't have that system, I will assume yes, but I haven't researched that question.
May a voter at town meeting move to amend a statewide referendum before it's voted upon?
No, it may not.
And is that because it's important for voters in a statewide referendum to be voting on the same question?
That's right.
And does that tell us something about the difference between a statewide question and a local question?
It does. And the city's position, going back to the argument that was talked about earlier, is that generally speaking, we look to the level of government at which the election is being held.
But a statewide referendum can be conducted at a town meeting, right?
Sure. And that's the Martin case.
That's right. And so is the issue the level of government at which the vote's being held, or is the issue the question? Are we all voting on the same question, or is each town voting on their own question?
I think perhaps I'm using different words to describe what Your Honor is getting at. My point is, Martin was a case that even though there was a statewide question that I've described in the city's briefing as being consolidated with town meeting day. But that election was conducted on a statewide basis, and it was
Everyone
coordinated
was
through
voting on the same question, whether the state should
Yes.
adopt prohibition by a certain date in 1915.
Yes, and it was coordinated by the Secretary of State's office. That was the election official for that election.
On the contrary, in the Slayton versus Town of Randolph case, each town was voting on their own question, whether their particular town should be a dry town or allow the sale of alcohol.
That's exactly right. And then going back to the Stowe Citizens case, in Slayton, the reason why that was a local election is because the court said that's an issue that was properly delegated to the local community to decide. It was an example where the legislature delegates down questions of how to implement state law at the local level. And so they were answering that for their own community. And it's the same for school budget. The school budget is about local funding priorities. And each community is looking at its own school budget, just like in Slayton.
And counsel, in the Martin case, what makes it statewide impact is that even though it was a local vote, is that the Secretary of State was certifying those results for the entire state in terms of that, correct?
Right. It was a question of general laws. In fact, the court didn't even have to get to the constitutional issue because the legislature said this will be conducted according to the general laws. Yes. If I may then, turning to sections 45 and 46 of the Ferry decision and how I feel that has effectively answered the question, if the court feels it needs to decide it, what is local versus state? And going off of what we've already talked about, this court talks about kind of two examples of things that get decided effectively at town meeting days. One, this court refers to section 6 of chapter 2 of the state constitution, referencing specifically the General Assembly's ability to charter local agencies. And your court spoke about the ability of the General Assembly to create local officers elected by local people and answerable to local people through its charter authority. Again, remember in Ferry, this court said chapter 2 of the state constitution is the charter of state government. The General Assembly charters local governments. And so chapter 2 doesn't deal with local governments. A school board is we're talking today not only about school budgets, but school board elections. The school board is the perfect example of what this court was referring to. Local school commissioners are elected at the local level, primarily to decide local issues, and they're answerable to local voters. This court also cited the Stowe Citizens case for the proposition that the General Assembly can delegate down to local agencies the power to decide local issues, purely local issues, or how to decide how to implement statewide legislation.
Counsel, doesn't Brigham fairly stand for the proposition that education is a statewide funding issue?
I disagree. Number one, Brigham spoke extensively about how Vermont has traditionally, the General Assembly has delegated authority for schools down to the local level, and this court effectively smiled on that practice. What this court said the General Assembly can't do is completely relinquish its obligation to make sure that there's equity in school funding. But beyond that,
So you're saying that equity in school funding across the state does not mean that school funding is a statewide issue?
the General Assembly has an obligation to make sure there's equity. Beyond that, everything is
But
effective.
the equity is money.
The equity is money.
It's tax dollars that come from 14 counties and all the cities, right? And towns.
Sure.
And so the vote from Brattleboro and the vote from Burlington each have an impact on what the equity will be and the tax dollars that will be raised and the tax obligation of the citizens in all 14 counties.
Under the scheme that the General Assembly came up with as a result of Brigham. But I want to emphasize that Vermont is a Dillon's rule state. Effectively, everything is a state issue in Vermont. The General Assembly has the ability to delegate its authority to create local governments under Section 6 of Chapter 2 of the Constitution, and to delegate, per the Stowe Citizens case, certain types of questions down to local communities. And so fundamentally, everything starts at the state until it's been delegated down to the communities. So education, there may be an obligation to ensure education, but that doesn't mean the General Assembly can't delegate that obligation. And in Stowe Citizens, this court specifically decided that school budgets are appropriately delegated down to the local communities. And that's the type of question that from Woodcock versus Bolster, this court said education, schools are local elections. I don't think the change in funding scheme changes that. And I think we have to be very careful to apply the test that appellants are proposing, because if we apply that test every time there's a change in the legislation, we have to look to see if that changes whether this is now a state versus local election. And we won't have that answer for each particular type of election until this court has answered that. I think that's a troubling
But
test.
doesn't Brigham actually say we do have that answer? Doesn't Brigham actually say that whatever legislature comes up with has to be statewide?
The legislature, Brigham said, has to make sure that the state provides, I'm probably not using the exact language, but a free and appropriate education for all Vermont children.
But that's tied into money.
Yes, it is.
It required equalization. It required equal amounts of spending per student statewide.
Sure. Sure, but the legislature has chosen to do that in a way that it still delegates the traditional decision of what the town school budget will look like down to the local community. Brigham didn't require the legislature to still delegate that down, but it did. And Stowe Citizen stands for the propositions that was okay. That's always been something that's been decided on town meeting day in Vermont versus at the Freeman's meetings. And I don't think that the change in school funding scheme changes that outcome. I know I'm nearly at time. Are there any other questions for me? Okay. Then just to sum up, again, I don't think because the test that appellants are asking for is the test this court rejected, I don't think the court has to decide definitively what is state versus local. But I think this court has already decided that, and I'd ask you to look at sections 40 or paragraphs 45 and 46 of Berry. And I would also point out again, as I indicated earlier, that this case is on point with Slayton, not with Martin, in that this is an issue that's properly delegated by the General Assembly to the local communities. And with that, thank you very much for your time.
Thank you, counsel. Does the appellant have any time remaining?
Appellant has 2 minutes and 28 seconds remaining.
Counsel.
Mr. Hess, before you begin, let me ask you this question, because I'm just still throughout the oral arguments of both parties. I keep coming back to this, so maybe you can help me here. You don't dispute that Burlington voters voted on delegated matters concerning Burlington's school district, right? You don't dispute that?
I don't dispute that they voted on
Okay.
Burlington's education funding.
Your only claim is that the state then exercised its state level authority by using those votes to regulate a host of statewide matters, correct?
I don't think that necessarily follows, Your Honor. I think what we're arguing is that, and to back up a little bit, my friend on the other side said that we're advocating a sliding scale test. We're not. And my friend also says that paragraphs 45 and 46 are kind of this court's decision in Ferry are where the matter ends. But if paragraphs 45 and 46 were all encompassing of the court's position, the court wouldn't have continued on to paragraph 49 and paragraph 50. The court wrote those for a reason. And in paragraph 50, it talks about school elections that are municipal in name, but traditionally province of Freeman in substance, and it cites Martin and Slayton. And our position is that the test is a comparison between Martin and Slayton, and that this firmly falls on the side of Martin, because in both cases, the legislature dictated a specific vote to be taken. In both cases, it was a quote, question of statewide public policy on which the votes of the town went into an aggregate, or the result went into an aggregate. And the issue decided was a quote, matter of general interest. Slayton, there was no statewide issue because as Your Honor discussed, it was a localized vote about whether the town after prohibition was going to continue to be dry. And that for that reason, the court said, quote, each town speaks for itself and for no one else. The result in one town has quote, no effect at all on any other town or the state at large. No general state policy was involved.
But in Martin, right, the voters in Burlington and the voters in Chelsea were each voting upon the same question, correct?
That's correct. And Martin was not
In-
confined
in-
to its facts
In-
as summarized by this
In a
court.
school vote, the voters in Burlington are voting upon a different question than the voters in Chelsea, correct?
They're both voting on how much the state should appropriate for per pupil spending. I think if you look at it this way, Your Honor, we have this hypothetical on page 4 of our reply brief. It's been in the news recently about potential school consolidations. If the state was to divide school districts into one for each quarter of the state, and they all were, equalized, I don't think anyone would contest that school funding votes have a statewide impact. It's the exact same principle. They're just divided a little bit.
Mr. Chief Justice, can I
Yes.
ask one last question?
You
please?
may.
Thank you. So following up on Judge Corbett's question, the vote wasn't just specifically about the budget. There were voters were asked to decide on who would be on the school board, various other local issues. Is that correct?
That's correct. And this is an as-applied challenge, and we're not disputing those matters, Your Honor. The state knows how to segregate, or the town knows how to segregate statewide votes and local votes. It does it already.
All right, thank you very much, Counselor. Your time has expired. Bailiff, I call the conclusion.
The next hearing for the court is scheduled for 10:45 this morning.
Thank you both.